not listening to a lawyer ramble on for too long. And then I've got some examples to kind of go through to show you where some of the pitfalls could lie. So the first thing, you probably expect this, get a lawyer, get something custom made for this. There's too many scenarios to think about if you are an employer and you're considering finding housing for your employees. So, for example, you could have housing that is owned by the employer and then rent it out to tenants. You could lease a unit and then sublease it to the tenants. You could offer some sort of rental subsidy or benefit to say, hey, I know nobody can afford to rent around here, but we are going to give you, $500 to your landlord each month just to help with that, on top of your salary. Or even shared landlord tenant accommodation. I don't ever recommend this, but I have seen it happen where employers will actually have their employees rent a room in their house. Okay, so all of those are different. All of those were covered by different acts in our laws, and all of them need different considerations when you're making the actual contract. Okay. One thing that you should be made aware of, BC's Residential Tenancy Act. So there is no contracting out of the Residential Tenancy Act. No matter how many times you say, I am not a landlord, you're not a tenant, we're employer-employee, it doesn't count. You are caught under that act no matter what. So make sure you're familiar with it and that you like the rules before you go in and start being a landlord. Okay. The other thing, Human Rights Code. So anybody that's an employer is probably already familiar that the BC Human Rights Code covers certain discrimination in employment that you are not allowed to engage in. So when I was working at a legal clinic for low-income people, there was a letter that one of our clients received that said, you are fired because you are pregnant. I wish I was kidding. That was the actual letter. Obviously, that's against the Human Rights Code, and that was a very easy case to win. Same thing for housing. Housing is also covered under the Human Rights Code. There's a couple different provisions. So for example, you can discriminate on the basis of criminal history and political belief in housing, but you can't in employment. Why those two? I don't know, but that's the way that the code works on that. Speaking of which, if anybody has any questions as I'm going along, feel free to unmute yourself and interrupt me. I don't mind, or send something in the chat here. I've got my eye on it as well. Okay. One thing to be made aware of, always taxes. So at the beginning of this, I asked if there was going to be an accountant on here. If there is an accountant, raise your hand and start speaking because you're more qualified than I am to start talking about this. But if you are providing housing, like you are subletting a suite for your tenant there, that will be a benefit and subject to those provisions of the Tax Act and Employment Act about providing benefits. So you give somebody a $1,000 a month, one bedroom suite to live in, then they will have $1,000 or $12,000 added on to their tax bill at the end of the year, or added on to their income to be calculated for taxes. Okay. Another interesting one that I've seen is housing cannot be used as an excuse to push somebody below minimum wage. So even if you provide housing to somebody and it would be a rather large benefit, that can't push somebody's actual, hourly rate in cash below minimum wage. What you can do is have them assign some of their paycheck to you instead. So this is a bit silly to think of, but let's say you have a minimum wage worker and you provide housing to them that's worth $1,000 a month. Instead of knocking their wages down $1,000 a month, the way you do that is you get their written assignment that, yes, you can take $1,000 a month out of my cash and pay it to yourself as my landlord. Okay. If you do wind up pushing somebody below minimum wage, they can go to the Employment Standards Tribunal and have that readjusted back up to where it should be. So big possible liability there that you can avoid with just a little change in how your contract works. Okay. Another thing you want to be made aware of, avoid the consequences of short-term tenancy. So some jobs are going to be for a very short amount of time. If it's less than a month, it's a short-term tenancy. And now you're going to have problems around collecting GST and such. So everything that I'm talking about here is for longer-term tenants. Now, Derrick, this all sounds like quite a hassle just to provide an employee housing. Well, you're not wrong, but there's one thing that employers have that most other landlords don't. And that is the ability to evict an employee who is no longer working for you. So you have a tenant, they are your employee as well, and then they decide that they're moving on to bigger and better things or going back to school or what have you. And so they have filed their 2-week notice. They say, I'm out of this job. It's been a pleasure. Goodbye. You can end their tenancy on the basis that they are no longer an employee. Now, any landlord will tell you that it's not easy to evict an employee, or sorry, it's not easy to evict a tenant. So having this option available is quite something. It has to be 1 month of notice, and it has to go to the end of the next period. So let's say that somebody stops being an employee on April 7th. And you serve notice, and they usually pay at the beginning of the month. That will be effective May 31st. So even though it's 1 month notice, it's not 1 month of notice. So that's the stuff that I thought would be most interesting and helpful to people. I have some examples to go through because just listening to a bunch of rules doesn't really make a lot of sense unless you have some sort of facts to apply them to and start to understand them. But does anybody have any questions before I move on to those? All right, hearing none, I'm going to do a screen share here, and hopefully I do this right. Pardon me. Host disabled participant screen sharing. Host, is there a way to change that?
Yep, all good to go, Derrick.
Okay, let's give that a try now. And then screen 2. Oh, look, it's magic. Can everybody see my screen? Oh, how about now? Can everybody see my screen?
You betcha.
Should say fact pattern at the top. Okay, I've got the right one. Perfect. So I thought these would be fun little things to go through. Starting off here, each of these, we have a landlord / employer who has done something that they probably oughtn't. So what we're going to do is go through and see if we can spot where they've made mistakes. So starting off, Albert operates a gas station in Golden and owns a large home in town. As an employee benefit, all employees are provided a room in the house to live in. Albert lives elsewhere. As a condition for living there, Albert has all employees sign an agreement that they are not tenants under the Residential Tenancy Act, but merely employees. Bart, a prospective employee, has a criminal record with an assault charge from 2016, but says he's reformed, and Albert decides to hire him and give him a chance. Out of caution for his other employees, though, Albert refuses a spot in the house to Bart, who rents elsewhere at his own expense. A few months later, Albert decides to sell the house to pay off some gambling debts that he owes. Bad Albert. Albert doesn't own any more houses, so he told his other employees to simply go find their own housing as well. What has Albert done wrong here? Anybody want to speak up? Anybody?
You can't opt out of the Residential Tenancies Act, even if they saw.
You got it 100%. No matter how many times you put it in writing and everybody signs off on it, you can't get out of that act.
You'll have to give 60 days notice.
Yes, he will have to give the full notice for that one there. That's correct. Anything else?
You should probably get some help with gambling.
He should get some help with his gambling, absolutely. And he should talk to a lawyer before he went through all this as well. One other thing, he has denied all his employees a benefit that they previously enjoyed. So he might be in trouble with the Employment Standards Tribunal for that. If that was in their contract, if that was a benefit that they were enjoying as a result of their employment and they no longer have it, he should be finding another way to provide it or compensating for that lost benefit, just like if you took away somebody's extended medical benefits, for example. Another thing, he has denied an employment benefit to somebody on the basis of their criminal record. So again, that will be a breach of the employment standards section of the Human Rights Code. Fun stuff. Okay, next one. I've just got 3 of these and the next 2 are shorter. Betty operates a bistro in Invermere. The business is incorporated as Betty's Bistro Ltd. She owns a large house through her company, Betty's Bedding Ltd., which exclusively rents to employees of the bistro at a reduced rate. The employees pay $500 on the first of each month, well under the $800 market rate. On April 7th, one employee provides their 2 weeks notice to end their employment at Betty's Bistro, and so Betty's Bedding serves 1 month notice to end tenancy effective May 8th. What do we think about this one?
Well, it wouldn't be effective May 8th. It would be effective May 31st, right?
You got it. Anybody spot the other interesting thing with this one?
They would have a taxable benefit of
They sure do have a taxable benefit. Yeah, that's a $300 a month taxable benefit that they're getting. Let's assume they pay their taxes. This one's a little bit tricky. Anybody else?
Could they evict them because they're not an employee of Betty's Bedding?
You got it. So I don't think the law as outlined in the Residential Tenancy Act is especially clear here. I don't actually know the answer to this one. I wasn't able to find anything that provided a detailed answer one way or the other because Betty clearly operates both. However, on the side of caution, I would think that because the landlord and the employer are different persons at law, these different corporations, that 1 month notice is not available. And so she will keep having to rent out to this employee at this reduced rate as long as the employee keeps paying their rent.
Derrick, what would be, how would you substantiate the difference in terms of market rate and subsidized rent? Like, so from an employment benefit perspective, in this case, we're saying that it would be a $300 employment incentive on their tax, like at the end of the year.
Mhm.
So would that just be a benchmark on some kind of a rental market report for the area that it's applicable to, or is it a bit of a, like, how do you define market rate in this case?
Great question for an accountant.
Yeah,
The law is that it's going to be, if there's a difference between what the employee pays and what the market rate is, that difference is an employee benefit and it's a taxable benefit. As far as CRA's policies and procedures to figuring out what market rate is, I don't know. In this case, maybe it wouldn't be I've told you the market rate is $800, but maybe it's arguable that, well, a room in this area, it's a big house, they have to share, 1 kitchen for 6 people, $500 is market rate. Maybe CRA is going to accept that. Maybe they're going to pull up the listings. I don't know.
Yeah,
That's a good question.
I guess one thing, if you were consistent, right, would be important. So you had a baseline standard where you weren't paying Joe, letting Joe pay 500 and Sarah's paying 800, and as long as it was equitable and consistent, I'm sure that would help.
Yeah, if you're transparent and fair, that's usually very helpful when it comes to dealing with CRA. Any other questions before we move on to the last one here?
Ada had one about market rate, but I think that was the same question I was asking.
Okay. Perfect. Actually, there we go. All right. And then the last one here. Let's get rid of that. Charlie operates a coffee shop in Canal Flats. I actually don't know if there's any coffee shops in Canal Flats. I haven't visited there myself yet, but we're going to pretend that there is one for now. He also operates a manufactured home park. His full-time employees make $35,000 per year, but he has a deal open for some of them where he provides them a manufactured home to live in at the park and pays the associated expenses, about a $15,000 a year benefit, but he lowers their salary to $25,000 for a combined compensation package of $40,000. He says this deal is great for his employees because not only do they get an effective $5,000 more each year, but they're going to report $10,000 less on their taxes each year, decreasing taxes and increasing any means tested benefits. What do we think about this one?
He's reduced their wage to less than minimum wage.
You sure got it. Absolutely. So wages below minimum wage, he could have avoided that by paying them $40,000 and having them assign, was it 15,000 to him in writing. Anything else? And again, it's that taxable benefit we were talking about earlier. So if they're reporting $10,000 less on their taxes, they're doing something wrong. They should be reporting 40 grand on their taxes, some of which is the salary that they're receiving, some of which is this housing benefit. And that's it. I hope that was informative, or at the very least a little bit entertaining. Does anybody have any questions for me at this point?
There's one in the chat from Leah.
Is it allowed to offer a housing benefit, but only to some employees, not all? Yes. So anytime you're doing something like that, you're going to want to have a policy that is fair and consistently applied and logical. Lawyers always get worried about things that are a little too discretionary, as it gives the opportunity for claims of discrimination. As you can see, if you were offering that benefit to all employees of one gender but not the other, you're going to have a problem there.
Derek, Pete here. Just for the small business owners that are out here listening in today, what would you say is a reasonable amount of time a lawyer would need to spend on crafting a specific employment agreement for a business to use with their employees? Is it 2 hours, 20 hours, 15 hours, 50 hours? Or is it like even just a ballpark hours would be?
Yeah. Tenancy agreements are not particularly complicated. And so long as there wasn't, a ton of extra special stuff that needed to be put in there, I think you're somewhere in the 2 to 4 hour range, if I was doing that. Less so, especially if you want, to make multiple for, many tenants, each additional one is 15 minutes, right?
Great, thank you.
All right, we have Robin and then Ben.
Sure, and this might kind of lead on from Pete's question. I was thinking when you said, as an employer, you can evict someone if they no longer an employee. Is that then part of the employee contract or the tenancy contract? So how does that work in the sense of how much paperwork do you need for that, I guess?
That's a good question. So that's under the Residential Tenancy Act. And I can't remember the section number, but you can go in and find it. It says one of the reasons that you can serve somebody a 1-month eviction notice is if the tenant is an employee of the landlord and the employment comes to an end, you can serve that 1-month notice. I don't know if it specifically, well, let me put it this way. I don't believe it specifically needs to be part of the tenancy agreement. I think prudence and caution would dictate that it should be in there so that everybody knows going into this, you no longer work for me, you're out of this house so I can give it to the next employee.
All right, we've Ben and then Aaron.
Hey Derek, I might have missed that initially there, but the source kind of documents you mentioned the Residential Tenancy Act. You touched on human rights code as well. Was there any other kind of source documents that you would be leaning into in order to create the employment lease agreements?
Yeah, so that's going to depend on the type of lease agreement that you have. So Residential Tenancy Act is going to be your big one. If it's a manufactured home, there's the Manufactured Home Trailer Park Act. I can't remember the exact specifics of the title of that one. Employment Standards Act, you're going to want to know if you're using this as a benefit for your employees. You should know, what happens if you remove an employee benefit or modify it, et cetera. those would be your fundamental documents. Now, you can create tenancies that aren't caught under the Residential Tenancy Act by living in a house with your employee. As I said at the beginning, I don't recommend it. That one's not cut under the Employment or the Residential Tenancy Act. And in that case, you're looking at common law, so just the standard law of contracts.
Look, a roommate agreement, right to occupy, that sense, as opposed to, I think the vast majority of people would want to try and distance themselves as far as possible from that scenario anyway. But
I would hope so, Ben. I would hope so.
Derrick, thanks very much. That was it.
Cheers.
All right, Aaron, and then we'll head over to the chat. There's a few questions there.
Perfect, thank you. I'm wondering how this scenario would work in, like, let's say, like, it might be if you have like a ski resort, for example, they might be able to rent out or hold rooms for their workers. But I'm wondering how, like, if a small coffee shop employed 10 people and they, like, what accommodations could they make to their workers if they don't have the means to maybe block off like a bunch of rooms at a hotel for housing or something. I'm just wondering how, like, if there's been any instances in your case where you've seen a coffee shop owner that's been able to, buy a certain piece of property to rent out to their workers, if you've seen any examples in that case.
Well, I think our next speaker is going to touch on that one, and I'm excited to listen to it. What I have seen is this was particularly popular in Banff, I believe, that people would own a house and then carve as many bedrooms as they could out of that house, and all of the people staying in those bedrooms were employees. So that's what I've seen before, and that was for a gas station, I believe.
Okay, thank you.
Perfect.
right.
So there is a question from Mike in the comments and Ada as well.
All right. Mike's comment: does the notice period work both ways? If an employer provides 2-week notice on January 5th, could we get housing notice for the 1st of February and still charge February rent? Okay, so let's see if I understand this one correct, Michael. So the employee provides 2-week notice on the 5th. So they say, I'm done with this job middle end of January. So you could provide your notice on January 5th, oh, you're going to give me notice, I'm going to give you notice. That notice would have to run to the end of February, and you still would charge for February rent. I hope that answers your question. Next question here is from Ada. If you want to provide housing to employees who are on 2 weeks on, 2 weeks off, how will the tenancy agreement work? Interesting question. If it's for an employee who gets exclusive use of the whole place for the full month, but they just happen to only be there for 2 weeks, nothing would change about what we have here. If you're trying to rent the same space out to 2 different people on 2-week terms, that's interesting. I'm not quite sure about that one. Shoot me an email to derrick@columbialegal.ca and I'll see if I can find an answer for that one. My guess off the top of my head is that you're looking at some sort of short-term tenancy situation, not too dissimilar if you went and Airbnb'd it to them for 2 weeks. So I'd be curious if that would be caught under the Residential Tenancy Act or not. I think it might be because of its repetitive nature, but that could be a fun one. Ooh, thanks for the interesting question.
Yeah, that's from me. Sorry, just a follow-up question, Derrick. Thank you for the information this morning. Is that if we have long-term tenants and we want to turn the space into Airbnb, how would that work for the lease agreement? Because we know we're new to BC.
Yeah, great question. So BC, especially in the recent years, has really ramped up the tenant protections when it comes to evictions. So the reasons to evict a tenant are very limited, and they seem to be getting more limited as time goes on. So that particular case, they just made a change.
Yeah, it's going to be the anchor tenant for them.
Mm-hmm.
And then the other one is who was it? Kinsel. They got the contract to build like the YouTube headquarters, which is a 400,000 square foot facility, and a couple of more Google operations. So I think they're looking to hire another 50 people in the next year here as well. So I think in terms of like a good time to lose jobs would be when we have a employee shortage, right? Yeah, they said 150 in their release. That's in US. So that's probably with US staff. So
I think you have a mute situation there, Teresa.
I was wondering if that's what's happening, actually. It's like, do you know him, Ada?
yeah, that's pretty.
Let me find.
I just muted him. We can carry on.
Okay,
Oh,
thank you.
I was wondering, have I not had enough coffee this morning that I'm not understanding this question?
Yeah.
Yeah, so to turn back to Ada, the ways that you can remove a tenant are getting more and more restricted. And in general, you know, removing somebody in order to convert a suite to an Airbnb is not going to be looked at favorably by the tribunal. So, and there are big penalties for attempting to evict somebody when you had no right to do so, including up to, I believe, 12 months of rent as a penalty. What I'm tending to tell my landlord clients in this circumstance, if they can, is to get the tenant on board with it. So, you know, some version of, hey, I'll give you a month of free rent if you leave on this date, will save you so much more hassles and headaches than actually trying to go through the process to evict them against their wishes, right? Good question, though. Okay. I think I have another question from Rob here. Elaborate on some scenarios where it is valid to only offer employee housing to some employees. Let's say you have 50, but you only have housing for 30. What obligation do you have to support the other 20? Good question, Rob. So if you are consistent in your policy, you're generally pretty happy. So in the case of the business you described, what I would like to see is some sort of agreement that says, right, I have housing available for my employees. It is done on a seniority basis. And when a spot opens up, it will be offered to the employee who has, you know, the most seniority that isn't currently in the housing, you know, going down the list until we wind up with somebody who wants it. That would be a good consistent policy that you could do in there. Or you could throttle it another way to say, right, you have to be at least 2 years working with us before you get it, or you have to be full-time. What I think you'd want to avoid is just being too discretionary with it. Again, anytime you can get too discretionary, you create an opportunity for an employee to look at the situation and say, well, right, you didn't rent to these employees who have this protected characteristic in common, but you did rent to these ones. You know, that's what you want to be careful of, even unintentionally. So having a policy in place that works for you is a good thing. Good question.
Derrick, if I may, I've seen an example where the policy is to support an employee in their first 6 months of their work, or especially with seasonal employees, you know, where we know you're having a hard time coming in, finding housing for the first season. So we'll set you up, we'll provide that for you. If there's available inventory to carry that on for a second season, great, we can keep you in there. However, if not, that priority shifts for those new employees that are coming in for the summer or the winter or whatever season's coming up.
Yeah, I agree with that. I think that the majority of employees will reverse engineer it, like you say there, Pete, rather than based on a seniority. It'll be you need to get them here to begin with. It's a case of creating that stepping stone for them to be able to get into the community. And there's other other methods in which you do that by slowly changing rates as well, depending on length of term. I've seen some employers do that in order to maybe you are slightly below market rate, moving to slightly above market rate in order to encourage the opening up of spaces for newer staff coming in.
Yeah, so what you've described there, Ben, see, there's a difference, because that sounds a lot like common sense, but lawyers don't deal in common sense. We deal in law. What you're describing there would be a violation of the Residential Tenancy Act on increasing rent during the first year of a rental.
Every 12 months, right?
It's every 12 months, and it's subject to a prescribed maximum of, I think it's
1.5% right now.
Something like that. Yeah, exactly. So, you know, you couldn't go from this nice cushy below market rate to a large bump up to above market rate. You'd have to go up by 1.5%. And similarly, Pete, great idea for the, okay, you get 6 months in this place, but after that, we're going to boot you out because you should have been able to find your own housing by then. Great if the employee goes along with it. That'll be beneficial to a lot of people who will consent. But if you have that employee that after 6 months says, you know what, I haven't found anything better, I want to stick around, you actually cannot evict them unless either, again, they're no longer your employee and you have that 1 month there, or you have some other valid reason. What you're talking about is called a fixed term tenancy, and they've been unlawful in BC for a little while.
So in that case, then you would need to guarantee them for the first year, and then you can make the change?
Nope. So in order to have a fixed term tenancy that ends on a specific date, the only thing in law that lets you do that right now is if a family member of yours is anticipating moving into that specific unit on the date that you're intending there. So you can say, okay, I'm going to lease this basement out to you. Well, my daughter is away in Ottawa for university, but she's coming back at the end of May. So we're going to end your tenancy in May. That's legal and enforceable. What wouldn't be is, well, I want to take advantage of the summer Airbnb season, so this tenancy ends in May. You see that advertised all the time, and that works for a lot of tenants who go along with it, but you couldn't enforce that one. If that tenant decides, well, you know what, I like it here, I want to stick around, they absolutely can.
Awesome. Great. Thanks so much.
Good question, though. Okay, there's one from Sammy here. What would happen if an employee had a family? Could the employer still help them or only allow single people? Great question. So when it comes to residential tenancy and families, I believe the rule off the top of my head is that if the person has to share kitchen space and a bathroom with, you know, this family, then you can discriminate and say, okay, no families, no kids. So in a big shared house situation, if you're renting out individual apartments or units or something like that, you can't discriminate just because they have a kid.
So with that, sorry,
Yeah.
Derrick, so I have a kid. Say I'm working for my company and the company is like, hey, we just bought some housing and units. And I'm like, oh, okay, great. Like, I'm a single person with a child. I would love to get on that opportunity. And they're like, oh, we just rented a house and it's shared housing. Would I then have a right to like talk to the employer being like, well, I'm still a single person just because I have a child? Does that, like, how does the laws work around that? Because I feel like that's a part of discrimination. Like, I don't know. What's your perspective?
Yeah, so it's a difficult one. Again, if it's a situation with a shared space with other people, you know, number one, you might not want to be in there with your kid, you know, just for personal reasons. But number two, I believe in that circumstance, they are allowed to say, no, we can take single people only in this one, no kids. If there is a benefit that's offered to everybody except the person with the child, we might have human rights code complications there. So for example, in the one little example I had, we had somebody with a criminal record and the person said, you know what, I don't necessarily want you with all my employees. They might not be comfortable with that. One of the things that you might be able to do is say, right, I'm going to give you a housing benefit. I'm going to give you some extra money each month based on what my rooms are worth for you to go find a room elsewhere. And that way, all the employees are being treated, not the exact same, but at least equally, right? And so that might be a situation that I could see certainly being more favorably viewed by the Human Rights Tribunal if that's the main concern there.
What if it was to affect your employment? Like say a ski hill wants to hire you to come work for them, but you have a child, and then you tell them that and they're like, oh, actually we can't offer you housing, so we also can't offer you employment. How would that?
That sounds like discrimination employment based on family status, which is unlawful under our human rights code.
Okay. Thank you for your time.
Good question. Okay, I've got Mariska here. Hopefully I pronounced that right. Okay, is it applicable for family with the individual bakery have our son working as a baker and his girlfriend at the store? Oh, it's awesome to see family things. They are permanently employed with this new project also work for them. They have a hard time finding affordable housing. If you're talking about the project that Christine is going to talk about, I'll let her answer that specific question there.
Okay.
And getting nods from you. Okay, perfect. And Ada, one last question. If we provide housing to contractors, not employees, will the tenancy agreement work the same as if we are renting to anyone who's not an employee? Ada, you were 100% right. If you are renting to a contractor, you don't get that lovely little 1 month notice to end tenancy. It has to be an employee. That being said, the line where you draw who is an employee and who is a contractor is always a tricky one, and lawyers love arguing about this in front of judges. So it's certainly something that you could bring forward if you have somebody who claims to be a contractor, but might not be.
Quick
Perfect.
question,
Thank
Derrick.
you so much.
I've got a quick one there. To Derrick, if you have an employee, recent hire, they're under a 3-month probationary period, does the BCRTA still, that 30-day termination clause still be in effect?
You got it. So you bring them on, and after 3 shifts, you know it's not going to work for this employee. So you terminate their employment pursuant to this probationary period. You give them the notice that they're entitled. Maybe it's nothing, maybe it's a week. I'm sorry, I can't remember the details. And you say, right, we're done with this. You still have to serve them the eviction notice that's going to keep them through the current month and also the next one. So you might not want to bring people in until they've passed through their probationary period. But of course, as discussed earlier, if the whole challenge is bringing people into town to begin with, you might have a little bit of a chicken and egg situation.
I have another quick question, Derrick.
Yeah.
If an employer was to talk to like an apartment or a hotel and ask them like, hey, could we like rent a certain amount of units where they're not the actual landlord, but they have an agreement with the landlord of the apartment, would it still work the same way?
Oh, that is such a great question. So in that circumstance, and I thought a lot about this one. So in this case, we have an employee and we have some other third-party landlord, and the employer says, right, I've got this deal with this third party to hold these places, to keep them open specifically for my employees. In that circumstance, any subsidy to the rent will still be an employee benefit for taxes, as I understand it. Again, accountant. But that 1 month notice that we talk about, that's such a big advantage, I don't think that's there anymore. So one of the things that you might want to see in this circumstance is for the employer to talk to the landlord and lease a number of the units and have in there the ability to sublease those units to their employees. And that's going to preserve that landlord, employer is the landlord, employee is the tenant that you need to have for that 1 month notice.
Thanks so much.
All right. Well, thank you everybody for your time. It doesn't look like we have any more questions at this point. If you do have anything that tickle your interest from this conversation, feel free to shoot me an email. It's in the chat there, Derrick, DERRICK @columbialegal.ca. And wish me luck on the housing hunt.